Today, I'd like to talk about Janke versus Vidal, a cert petition filed by a pro se patent applicant. Frankly, the likelihood of the Supreme Court taking it is basically zero. But, despite the fact that I don't think this case is actually going to go anywhere, it raises an interesting question about eligibility jurisprudence. And so I would like to talk about that and talk about the question because we know the Supreme Court, frankly, is not going to do that. So here's the question. Janke invented a rake. It's a rake, it's got little holes in the tines, and there's a string strung through them, and what that does is it prevents leaves from collecting in the rake while still maintaining the flexibility of the rake itself. Okay, fair enough. I've never used it, don't know how well it works, but he thinks it's worth a patent, so good for him. He got claims to this rake allowed, but there were also claims to a mathematical model of the rake, and those were rejected under Section 101. So he appealed this. The examiner was affirmed. He went to the Federal Circuit. It was an affirmance under Rule 36, which basically means affirmed without opinion because they don't think it needs an opinion. And they just said, we are affirming the lower tribunal. In this case, they were affirming the Patent Trial and Appeal Board. And so now he is going to the Supreme Court. And he asks two questions, and the one that I think raises sort of interesting issues is the second one, which is, can it be too much patent monopoly to preempt, in practical effect, a mathematical model of a product as no one is disputing follows from Gottschalk versus Benson when it is known that it is not too much patent monopoly to preempt the real product itself? This is an interesting question because it talks about sort of the tension that exists in this idea of you want to use Section 101 to prevent preemption because, as this question rightly implies, patents are all about preemption, right? That's the thing they do, is they preempt. They give you exclusive rights to, a machine, a method, article of manufacture. And so isn't there something sort of incoherent about the concept of preemption being something you want to avoid? Problematically, though, I think that this question misses some things that are kind of important about patent law and about Gottschalk versus Benson, which is why I want to talk about it. The first thing is, so the question says, is it too much monopoly to preempt a mathematical model as no one is disputing follows from Gottschalk versus Benson? First point, I dispute that follows from Gottschalk versus Benson. So that was a case where the invention was a method of converting decimal and binary numbers. And the Federal Circuit said, hey, this is a mathematical method, but its only practical application is on a computer. Therefore, it is something that can be patented. This was way back in the early 70s. So that goes to the Supreme Court. The Supreme Court says, hey, no, actually, it goes the other way. You can't patent math itself, right? If you came up with the equation a squared plus b squared equals c squared, you couldn't patent that equation. And yes, you can patent applications of equations, but in this case, the only applications of this equation are on the computer, and so if you patent the computer performing the equation, you are in effect patenting the equation itself, and therefore you can't get that patent. You are in effect patenting mathematics, so you don't get it. Now, to my mind, that's very, very different from saying you can't patent a mathematical model, because, okay, you say mathematical model, that's math. True. On the other hand, there's a big difference between saying, hey, I have an equation for calculating the force on a tine in a rake versus I have a mathematical model of a rake that uses that force equation in order to sort of model what this rake is doing. So to my mind, that actually does not follow directly from Gottschalk versus Benson because there's a difference between the equation itself, like F equals ma, versus a application of that equation in a mathematical model of a rake. So that's my first comment on this, it's an interesting question, and I think it shows a tension that exists in patent law, but it really, I think, also fundamentally misunderstands Gottschalk versus Benson. Now, that raises another question, though. Why are we talking about Gottschalk versus Benson? I will say the last time I got a rejection from the patent office that cited Gottschalk was never, actually. And unfortunately, I do get 101 rejections, and then you have to deal with them, and you do. But I don't think I've dealt with them or had to overcome Gottschalk versus Benson, like I said, ever, right? People now are focusing on Alice, Mayo maybe, the more recent Federal Circuit decisions, but these are things that happened 2014 or later. We're not talking about decisions that are like 50 years old. So where is this coming from? Well, this is a case with a funny little history. So originally, when this case first came up before the patent examiner, there were no Section 101 rejections. There were some rejections. I think we've got some 112s in here. Yeah, there's some 112s. We got a couple of 103s. But there was nothing under Section 101. And Janke apparently had an idea. He wanted this to be dealt with under Section 101. And so what he did was he said, hey, all right, here are my reasons. I'm going to deal with the 112s. I'm going to deal with the 103s. But we should have an interview because I think this should be rejected under Section 101. Let's have an interview, and you can tell me why. Here are all my arguments for why this is unpatentable under 101 are invalid. And the examiner said, well, forget that. We'll have an interview, and I'll just reject you under 101, which is exactly what happened. Then he went to the Patent Trial and Appeal Board, and he said, you know, this is totally invalid under Section 101, under the current subject matter eligibility jurisprudence. Therefore, I agree, you shouldn't reverse the examiner. And unsurprisingly, the appeal board did not reverse the patent examiner. And the same thing happened at the Federal Circuit, which is why we are set up with kind of a weird question, which includes, as no one is disputing, follows Gottschalk versus Benson, because no one was disputing it, because no one was actually saying that except for Janke himself. So it's an interesting case, and it is an interesting question. I think it raises a tension at the heart of 101 jurisprudence, but I think it also shows how far we've gone from that original preemption, because that was the reason why originally, sort of Gottschalk versus Benson, they said you can't get this claim is because it would preempt this mathematical relationship in practice. And that really is not the reasoning we use anymore. We've moved well beyond that into this sort of nebulous, undefined, abstract idea. And as a result of that, questions like this really aren't raised anymore, at least not outside of this very specific case, which, as I said, the Supreme Court I don't think is going to take up. And as a result, if you're trying to look at it from first principles and you look at the history, they're really, it really just doesn't hold from the first principles. There's no straight line from Gottschalk to where we are today. But anyway, that's all I wanted to say. Again, I think it's an interesting case. I think it raises an interesting question, talks about some interesting tension. But at the end of the day, it's not something that has a lot of practical application because this isn't a question that people are asking with the exception of Janke himself. All right, talk to you later. Bye-bye.